230 years and 4 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The sixth article was approved by the House of Representatives on August 24th of 1789, by the Senate on September 9th of 1789, and by the Congress at large on September 25th of 1789 without modification, and reads in full, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." One severe curtailment of these provisions resulted from Terry v. Ohio, 1968, in which the Supreme Court ruled that police may stop and question pedestrians on the street even without probable cause to arrest, so long as the officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime, and that police may perform a surface search of the person's outer clothing for weapons if they have reasonable suspicion that the person stopped is armed and presently dangerous, though that suspicion must be based on specific and articulable facts. This resulted in what has become known as a Terry frisk, and when extended to the temporary detainment of persons in vehicles, to Terry stops, which laid the groundwork for pretextual stops, in which police are authorized to stop vehicles for minor infractions in order to investigate a person on other suspicions. Associate Justice William O. Douglas voiced a sharply dissenting opinion in the case, arguing that "We hold today that the police have greater authority to make a seizure and conduct a search than a judge has to authorize such action. We have said precisely the opposite over and over again. To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment.